Good morning. Let us come to order and go on the record. I am Tanola D. Brown Bland with the North Carolina Utilities Commission, presiding commissioner for this hearing. And with me are Commissioners Floyd B. McKissick Jr. and Jeffrey A. Hughes. I now call for hearing docket number W-1297, sub 14, in the matter of complaint of MRT-1 LLC versus Harkers Island Sewer Company pursuant to North Carolina General Statute 62-73 and Commission Rules R1-9, R10-6, and R10-13. On May 2nd, 2019, Pinnacle Bank, successor in interest to Bank of North Carolina, filed a complaint against Harkers Island Sewer Company, hereafter HISCO, alleging that HISCO unreasonably refuses to provide wastewater service to lots located in the James Creek subdivision in violation of its duties as a regulated public utility. Among other things, the complaint asked the Commission to order HISCO to provide sewer utility service to said lots, to appoint an emergency operator to establish sewer utility service to all of HISCO's franchise territories, including James Creek subdivision, to deny HISCO's request for a bond reduction, to order that HISCO be required to pay for any required additions, extensions, improvements, or repairs to HISCO's existing facilities, and to not require any present or future owner developer of the James Creek subdivision to solely bear the cost of any new wastewater treatment facility that is determined necessary to service the James Creek subdivision and that would be intended to service areas outside of said subdivision. On June 14th, 2019, HISCO filed answers and responses to the complaint and amended the same on June 17th. On October 21st, 2019, MRT-1 LLC filed a reply to HISCO's answers and responses and requested to be substituted as the complainant. On October 22nd, 2020, the Commission issued an order granting MRT-1 LLC's, hereafter MRT, request to substitute as complainant. On November 3rd, 2020, MRT notified the Commission that HISCO's answers were not satisfactory to it and requested a hearing on the complaint. On December 18th, 2020, the Commission issued an order scheduling hearing, establishing procedural schedule, and adopting discovery guidelines. The order scheduled the hearing for April 27th, 2021. On February 26, 2021, MRT filed the direct testimony and exhibits of Dan Timberlake and Tim Reagan. On March 1st, 2021, MRT filed an additional exhibit. On April 5th, 2021, HISCO filed the direct testimony and resume of James W. Bill Foreman and the direct testimony and exhibits of Mike Laws. On April 13th, 2021, HISCO filed a motion to continue the scheduled hearing. On April 16th, 2021, the public staff filed notice of intervention, mediation, and request for continuance of complaint proceeding. The public staff's intervention is recognized pursuant to North Carolina General Statute 62-15D and Commission Rule R1-19E. On April 19th, 2021, the Commission issued an order continuing hearings, suspending procedural deadlines, and requesting status updates regarding mediated settlement discussions. On June 2nd, 2021, the public staff filed a report stating that mediation was not successful, and on June 15th, 2021, the public staff requested the Commission to hold this matter in abeyance to allow HISCO time to continue ongoing discussions for the possible sale of its wastewater utility system. On June 16, 2021, the Commission issued an order holding the proceeding in abeyance and requiring status update. On September 14, 2021, the public staff notified the Commission that HISCO had not reached an agreement to sell the utility and requested the Commission reschedule the hearing. On October 13, 2021, the Commission issued an order rescheduling the hearing for December 14, 2021, and establishing new procedural guidelines. On October 18, 2021, MRT filed rebuttal testimony and exhibits of Dan Timberlake. On November 29, 2021, the public staff filed its recommendations and exhibits. On December 7th, 2021, Hisco moved the commission to continue the hearing due to an emergency situation with counsel. On October 8th, 2021, the commission granted the motion and continued the hearing. On December 9th, 2021, the public staff filed modified recommendations. On June 13th, 2022, the commission issued an order scheduling an expert witness hearing for today, August 17th, 2022, at 10 o'clock a.m. in the commission hearing room in Raleigh, North Carolina. On August 8th, 2022, Michael Janess filed a notice of appearance, substitution of counsel for Clark Wright as attorney of record for Hisco. In compliance with the requirements of the State Government Ethics Act, I remind all members of the commission of our duty to avoid conflicts of interest and inquire whether any member of the commission has a known conflict of interest with regard to this docket. The record will reflect that no conflicts were identified. And now call upon counsel for the parties to announce their appearance for the record, beginning with the complainant.
Good morning, Madam Chair, members of the commission. My name is Andrew Irby, IRBY, appearing as counsel for MRT-1 LLC.
Thank you, Mr. Irby.
Good morning. My name is Michael Janest of the Forge Law Group, here on behalf of Harkers Island Sewer Company.
Good morning, Mr. Janess. Do the parties have any preliminary matters or anything that has changed that needs to be brought to the commission's attention?
No, Your Honor.
At this time. All right. If not, we'll start with well, let me just stop for a minute to say a little bit about the proceedings. So I think you all know that I've asked for opening statements and roughly given each side 15 minutes for opening statements. And what I'd like to know is I hope you will cover the issues that you want the commission to decide and determine within that. And then we'll start, the case will move to the complainant to put on its case, put up its witnesses, verified that their testimony that they pre-filed is the testimony they would have today if asked those same questions, and get exhibits identified. And then those witnesses, as typical practice here, will then be made available to cross-examination. And then move into, when the complainant's done with its case, we'll move into respondent's case. And then complainant can put on a rebuttal case if necessary. And the public staff wants to tell me something, so you didn't identify yourself, that's right.
I didn't identify myself.
I'm sorry.
Good morning, Chair Brown Bland and Commissioners. I'm Gina Holt, Manager of the Public Staff Legal Division's Natural Gas, Water, Sewer, Telephone, and Transportation sections, here on behalf of consumers today.
All right, thank you, Ms. Holt. I'm sorry I overlooked you, I don't know how I managed to do that. So with that said, we'll move into opening statement portion, and you can move up and stand if you wish, or you can take it from right there at council table.
Thank you, Madam Chair. If please, court, I'll just stay where I'm at since I've got all this stuff in front of me, and I don't want to unnecessarily move back and forth.
Perfectly fine.
Once again, my name is Andrew Irby. I'm appearing on behalf of MRT-1. This is not a simple case, and there is absolutely no simple solution to this case. The case is simply about retribution and not much else. For the record, there's no dispute that Harkers Island Sewer Company, which I'll refer to as Hisco, no longer has capacity to serve any new lots or customers within any of its franchise territories. All of the information that has been provided recently indicates that 100% of the permitted capacity allocated to Hisco has been utilized, with the exception of, maybe 100 gallons, but not enough to serve really any new customer within the franchise territory. With that said, for a series of years, dating back to potentially 8-10 years, Hisco has intentionally and knowingly denied service to the owner of the James Creek subdivision following its foreclosure, and provided service to new franchise territories and new customers throughout that entire time period in which the owner of James Creek was asking for service. The evidence will show that the previous owner of James Creek subdivision, BLE Development LLC, is managed, or at least was managed, by the same manager as Harkers Island Sewer Company. This was a developer who developed a sewer company to serve not just his own developments, but to expand service on the island to other developments. In 2014, Bank of North Carolina foreclosed on the James Creek subdivision and almost immediately began requesting connection to wastewater treatment services so that James Creek could be developed, so that the bank could recoup money on its lost investment in the James Creek development. Almost immediately, Harkers Island Sewer Company, instead of discussing options to connect to its existing wastewater treatment plants, to expand capacity of existing wastewater treatment plants, almost immediately began demanding that Bank of North Carolina and its successor by merger, Pinnacle Bank, construct a new wastewater treatment facility. Not only that, no allocation or pro rata distribution of the costs were provided to Bank of North Carolina or Pinnacle Bank. This is throughout the entire 8-year period between 2014 and the present date. The evidence will show that in that time period, Harkers Island Sewer Company had plenty of capacity to provide service to all of the lots within James Creek Phase 1, and as time went on, to some of the lots within James Creek Phase 1, including up to the date the complaint in this case was filed. And the entire time, the only demand was that MRT-1 or its predecessor in interest, Pinnacle Bank and Bank of North Carolina, construct a new wastewater treatment plant. Long story short, Harkers Island Sewer Company violated its duty as a public utility to serve the public. The only entity that has the right to reduce service to an existing franchise territory or to eliminate service to an existing franchise territory is the commission, not the public utility. And in this particular case, Mr. Laws, the principal of both BLE Development LLC and Harkers Island Sewer Company, refused to allow James Creek to be developed if he could not develop it himself. The evidence will further show that Mr. Laws intentionally rendered the existing James Creek property ineligible for any septic or wastewater treatment plant on site. Immediately before the foreclosure was completed by Bank of North Carolina, the entire property was timbered, rendering all of the old growth that would have facilitated an existing wastewater treatment, the construction of a wastewater treatment plant, or any of the lots to perk on their own, impossible. It means that the current owners and the prior owners of James Creek had only one option for sewer service, Harkers Island Sewer Company. And instead of having lines extended or capacity expanded the entire time between 2014 and the present date, Hisco has required or demanded that owner of James Creek build a new wastewater treatment facility. We believe this is an inappropriate request given the public utility's duty to serve the public and not pick and choose which customers are going to get served as opposed to which ones it wants to serve. We are requesting a number of things. As Chair Brown Bland pointed out in the opening statement, we are requesting that an emergency operator be installed for the sole purpose of facilitating the expansion of the wastewater treatment plant that presently exists on the island. We don't believe that the existing plant has a lifespan that will last very much longer. The parties agree that the existing wastewater treatment facility is at the end of its useful life and that ongoing maintenance costs are going to be incredibly expensive for the existing customer base, for the existing rate-paying public. So it makes sense that Hisco would want to build a new wastewater treatment plant. What does not make sense is that they want MRT to foot the full bill. MRT does not want a free ride. It's not asking for anything to be provided for it, and it does not want the rate-paying public to provide service for James Creek. It does want a solution for the island. It does want to pay its fair share, and to date, we've not been provided any of those options other than you build us a wastewater treatment plant and we'll provide you with service. So we are asking for a third-party operator to be installed to act as an honest broker to facilitate the either expansion, repair, maintenance, or construction of a new wastewater treatment facility. The next thing that we're asking for We're asking for the, sorry, Your Honor, I'm looking for my notes for the specific. We would like for the commission to give Harkers Island Sewer Company time to present multiple options, not just one option for construction of a new wastewater treatment facility, but multiple options to expand the existing wastewater treatment plant to improve its lifespan without having to build a new wastewater treatment facility, or to provide additional options to slowly replace the wastewater treatment facility. But we'd also like those costs to be allocated. And we'd prefer it if some of these plans came from more than one engineer, given that the current set of plans we believe to be prohibitively expensive and not the most cost reasonable or cost effective way to repair the existing wastewater treatment facility. We'd also like the ability to have our own expert go into the site to conduct an analysis of how capacity can be expanded without having to either construct a new wastewater treatment facility or to actually provide an allocation of resources for the construction of a new wastewater treatment facility. Next, we're asking the court to exercise its powers under 62-37 to conduct an investigation of Harkers Island Sewer Company. Not just an investigation of the complete management audit that the commission is empowered with, but we'd like an audit of Harkers Island Sewer Company's revenue streams and books. We don't know the long-term financial viability of HISCO right now. We don't know what its long-term debts are. We don't know where the revenue is going once it's accepted. We do believe that there have been some accounting practices that make it appear as though this property is worth more than it actually is, given that the existing wastewater treatment facility is at the end of its natural life. Next, we would like, to the extent that Harkers Island Sewer Company cannot comply with any of this commission's orders, for the commission to exercise its powers pursuant to 62-310 to fine Harkers Island Sewer Company for every day that service is not provided to James Creek, given its public duty. Finally, MRT would like the option to construct our own wastewater treatment plant, including on HISCO's property, to expand its current plant. Once constructed, to turn over to Harkers Island Sewer Company the operations of that plant. As an alternative, MRT would like the option to provide notice to HISCO and to the commission to just leave the franchise territory so that we can explore options to establish our own capacity. We don't want to be forced to do that. We want an option for the whole island. We want to try and help the whole island. We want to try and help Harkers Island Sewer Company. But if push comes to shove, we'd like to exercise an option to leave the franchise territory to go at it ourselves. Thank you.
Thank you. We'll hear from you, Mr. Janess.
Good morning and thank you. We fundamentally disagree that this is not a simple case. It is a simple case if what is left off the table is the attempts to wrangle a Superior Court civil suit into the Utilities Commission. What MRT-1 is attempting today is to raise a kind of a pseudo contract claim or implied contract claim, which would have no legs in Superior Court, and they know that. They're trying to, through the Utilities Commission, force this public utility to give them special treatment, and yet are sitting here saying that that's exactly what they don't want. It's incredible to me that in the pleadings and in the opening statement and in the all the communications that I've seen in this case, MRT-1 is asking explicitly for plant improvements and increase of capacity of the Harkers Island Sewer Company without MRT-1 paying for it. And then they say that they don't want a free ride. That is the definition of a free ride. The idea that HISCO has an obligation to MRT-1 is partially true. HISCO has an obligation to all of the consumers in its area and has for more than 10 years conscientiously, carefully, and to its occasional detriment, served the public of Harkers Island dutifully. it has at every turn made what capacity it has available or can procure, has made that available on a first come, first served basis to the consuming public, including to the predecessors entitled to MRT. MRT bought this property after the responses had been filed in this immediate case. As the commission is well aware, this case has been going on for more than 2 years. MRT had full notice that there was no capacity available to serve the James Creek subdivision with the current plant in place. They are choosing to gamble that they can spend their money on a legal fight and get themselves a free treatment plant instead of doing what every other developer has done, should do, and that's to pay for either increase in plant capacity through HISCO or the creation of their own treatment facility on site. The statement that no options have been discussed is simply not borne out by even the exhibits presented by MRT here today. There have been extensive conversations with Bank of North Carolina, Pinnacle Bank, and now with MRT as to what their options are as to HISCO's exploration of different methodologies by which James Creek can be served. For MRT to come to the evidentiary hearing 2.5 years into this case and ask for time to get an engineer is surprising to me. It's very surprising to me. We've had discovery in this case. We've made our engineer available throughout this case. There's never been any prohibition on MRT conducting its own research, on hiring its own engineer. I don't know why we would be sitting here at what ought to be the tail end of this case, asking for time to explore, time to hire an expert. MRT would like to make this case about retribution that it apparently put itself in the shoes of the aggrieved party intentionally, and it simply isn't. There is not, well, the testimony that this commission will hear will show that HISCO has always even-handedly, and again, on a first come, first served basis, and on a negotiated basis. So when HISCO has needed to add facilities or not necessarily capacity, but to add the ability to serve new customers, those new customers have paid for those increases in HISCO's capacity, as is the law, as is the practice, as everyone else does all the time. HISCO is asking that the commission obviously deny MRT's requests for, well, all of MRT's requests. HISCO stands by and is prepared to serve James Creek. There is no retribution. There is no refusal to serve MRT or the James Creek subdivision as long as the developers of the James Creek subdivision do what they need to do to acquire that capacity. We're not denying them service on any sort of personal basis. There is no retribution. There is no vendetta against the current holders of that development position. All we ask is that MRT be treated like every other customer of HISCO. I have a number of other contentions to make about the allegation that James Creek is not able to have a wastewater treatment facility because of logging. That's just not true. The evidence will show that that is not true. The testimony will show that that is not true. Additionally, the Testimony will show that Hisco has made offers in the past to assist MRT and its predecessors in title in placing wastewater treatment facilities in James Creek or expanding other sites so that James Creek can be served. There is no call in this case to penalize the public service of Hisco for the sake of one developer. And the idea that a developer who intentionally put themselves in this position would be able to extort millions of dollars that would in fact bankrupt the public utility is just, it's beyond the pale, and there's no call for it in this case. That's all I have. Thank you.
All right, thank you. So now cases with Ms. Holt. I'm about to leave you out again.
Good morning again. The public staff's involvement in this case has been that it's been to serve as a mediator. The mediation failed. Consistent with the public staff's April 16, 2021 notice of intervention, the public staff will not be presenting any witnesses at this hearing. The public staff's recommendations filed on November 21st, 2021, and the modified recommendations filed on December 9th, 2021, were the product of the mediation and were offered in the spirit of settlement. The public staff will not seek to admit these recommendations into evidence at this hearing. While the public staff is not presenting a witness, we have reserved the right to cross-examine the witnesses called by the other parties. Thank you.
Thank you, Ms. Holt. And now the cases with the complainant. You may call your first witness.
Your Honor, my first witness is Dan Timberlake.
Mr. Timberlake, if you would come up to the witness stand. Yes, if you place your left hand on the Bible, raise your right. Do you solemnly and sincerely swear that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
All right, you may be seated.
Would you please state your name, position, and business address for the record?
Dan Timberlake. My business address is 1714 East Center Street Extension, Lexington, North Carolina. I'm a principal and one of the 3 managing members of MRT-1.
Okay. On February 26, 2021, did you pre-file direct testimony consisting of approximately 13 pages along with the accompanying exhibits labeled A through K?
Yes.
If I were to ask you those same questions today, would your answers be the same?
Yes.
Do you have any changes or corrections to your testimony or your exhibits?
No.
On October 15th, 2021, did you pre-file rebuttal testimony consisting of approximately 5 pages and additional accompanying rebuttal exhibits?
Yes.
If I were to ask you those same questions today, would your answers be the same?
Yes.
Do you have any changes or corrections to those rebuttal exhibits filed along with your rebuttal testimony?
No.
Chair Brown Bland, I move that Dan Timberlake's testimony, direct testimony and rebuttal testimony be copied into the record in this proceeding as if given orally from the stand, and that the exhibits attached to his direct testimony labeled as A through K and the additional exhibit that was filed labeled additional exhibit be identified as marked when filed.
All right, Mr. Irby, do you intend to submit the witness on his rebuttal all in one swoop, or do you want to bring him back a rebuttal following the respondent's case?
If it's okay to reserve bringing him back as a potential rebuttal witness following the defense case, we can do that.
So in that case, it would be most appropriate to
Limit it to the
bring
direct
in
testimony.
the rebuttal at that time,
Yes, ma'am.
just for the record to be clear. So I will receive the witness's direct testimony as if given orally from the witness stand, and the exhibits that were attached to the complaint let's mark them to be in line with the usual convention of the commissions. So they will be identified as MRT, Timberlake, direct exhibits A through K. And the additional, let's have it marked as L, Exhibit L. All right, and the testimony is received into evidence at this time.
Thank you, ma'am. I tender the witness.
Good morning, Mr. Timberlake.
Good morning.
Mr. Timberlake, were you aware of this lawsuit when you purchased what's known as the James Creek subdivision?
Yes, I was.
Were you aware of the response filed by Hisco in this case?
Yes, I was.
And you knew at that time that Hisco had stated publicly that there was no capacity available to serve the James Creek subdivision?
No, I was not aware of that.
Did you read the response filed by Hisco in this case?
At some point I did. I have no recollection of there not being capacity. When we purchased this, I used to be an attorney, practiced law in the late 80s and early 90s. This was platted. It was platted with Carteret County, Plat Book 32, page 403. On the, there's representations to the public in the recordation of the plat. And Mr. Law signed on behalf of BLE Development to certify that all the utilities were in place. He also certified to the public that Hisco had the capacity, had built the plant, and would serve sewer to the property. So these public representations were made. Were we aware that there were issues? Yes, we were aware. Was there capacity at that time? Our understanding, there was capacity in taps.
At what time are you referring to?
When we purchased property.
In 2019?
I think so. I even remember one tap. There was one lot that was sold to another individual. I think it was lot 49. And we've had ongoing conversations with that individual and referred him because at some point Mr. Law said he had a tap. Now, the main connection between the sewer and the infrastructure that's in place at the subdivision was never made. And as Tim Reagan, MRT, we develop property. We've never seen a situation where a county would certify a plat and allow it to be recorded unless there was a performance bond ensuring that whatever work that was remaining would be completed in case the developer went away. The developer in this case for the existing subdivision was Mr. Laws and BLE Development. We are not a developer of James Creek subdivision. It is platted, it is recorded, the infrastructure is in, the connections can be made to sewer, water, and electric.
In 2019, did you speak with Mr. Laws about how much capacity was available to serve James Creek?
I don't recall. I think Mr. Reagan may have spoken with him, but I don't personally recall speaking with him.
As part of your due diligence, did you seek information about how much actual capacity there was to serve James Creek?
No, I do not recall that.
Do you recall what the date was approximately of the plat that you're referring to?
I do not. I want to say 2014, but I'm not sure. Actually, I think it was 2013. I think the plat was recorded in 2013 because I think the foreclosure took place in 2014.
You were aware of the foreclosure, correct?
Oh, yes.
And you were aware that the on-site facilities for wastewater treatment had never been constructed at James Creek.
Based on the existing permit at that time, it wasn't required. That was not part of the plan, that it was actually going to be treated or served by a force main to West Bay.
But you were aware that well, let me ask that differently. There was a wastewater treatment facility contemplated and platted for James Creek, correct?
That's correct, and that was going to be phase 3 of the strategy to serve a much larger subdivision.
And you were aware that that had never been constructed, correct?
Absolutely.
And did you, through this purchase, acquire the land on which that wastewater treatment facility was supposed to be built?
Yes, we did.
Have you deeded that land to Hisco?
Nobody's ever requested it. No.
Are you the developer? Are you in the shoes of the developer in the original agreement?
No.
You expect Hisco to meet its obligations as you see them to the quote unquote developer, right?
We do not know that there should not be any obligations to the developer because the property is developed, it is platted, it has been certified to the public, representing to the public that the utilities are available. So there is no status or facet of a developer for the existing platted lots in phase 1. If you're referring to the potential for the additional capacity, as James Creek has been pre-approved for 80 lots, and that would be phase 2. And I think that's what Mr. Law's original vision was for not only James Creek, but for Hisco and the permit that was in place. Yes, we are not, we're not opposed in any way, shape, or form, never have been, to paying what we need to pay to increase the capacity of Harkers Island Sewer Company. What we refute and what we take issue with is we have never been provided any information of any allocation. We've simply been given a number of $1.1, $1.2 million. With no allocation of, well, how much of that is to increase the capacity? How much of that is to serve the existing lots? How much of that would in turn serve your existing customer base? Well, the answer impliedly is it's a brand new plant. I take issue with your opening comment about we now need time to hire an engineer. We have engineers. We know, have a reasonable degree of confidence in what it will cost and what it will take to take the existing facility. But our engineers have not been on site. They do not have the information. It is not publicly available. It has not been provided to us. We have serious questions about the financial stability of Harkers Island Sewer. And because there's a public plat, if for any reason whatsoever Harkers Island system should fail, we don't understand what will happen and how it would be fixed. But we came to this action and we came here today. We're prepared to do whatever we need to do within reason. We don't have an axe to grind with Hisco. We don't have any ill will. We just simply wanted to continue to develop the 30 acres and to get our existing development served by sewer.
You stated that you have your own engineers. Have you, I take it you did not bring an engineer here with you today. Is that correct?
We saw no need for one.
Did you submit any testimony from an engineer?
We saw no need for that.
Are you an engineer, sir?
No, sir.
Are you a utility contractor?
No, sir.
So then in this evidentiary hearing, is there any competent testimony as to the cost to perform these increases in capacity other than the licensed engineer and the utility contractor sitting next to me?
I'm not aware of any.
Have you developed other subdivisions, Mr. Timberlake?
Yes.
You know the difference between a will serve letter and a reservation of capacity?
No, we have not developed another subdivision where there was a privately held public utility.
In dealing with publicly held public utilities, have you encountered the difference between a will serve letter and a reservation of capacity?
No,
Have you obtained a reservation of capacity in this case?
I do not know. You'll have to define reservation of capacity.
Were you assigned any agreements between your predecessors in title and Hisco that guaranteed capacity for the James Creek subdivision?
I'm not aware.
Have you requested the ability to reserve capacity at the existing Harkers Island wastewater treatment facility?
I don't understand the question.
Do you know the difference between actual capacity for a wastewater treatment facility and the permitted capacity?
Yes,
And you're aware that the law governs how much of that permitted capacity can be allocated to different consumers, right?
if you're asking me if I'm familiar with the law, no.
You're not familiar with it. Okay. Are you aware that the allocation by the sewer company is governed by rules and regulations that dictate how the service is allocated?
Could you repeat that?
Yeah, I'm asking you whether you are aware that Harkers Island Sewer Company, as a public utility, is required to follow rules and regulations that dictate how its capacity is allocated.
I presume that to be the case, yes.
I'm going to save that question for later. In your testimony, you referred to a 2011 contiguous service area application. Do you recall that?
Not specifically, no.
I'm going to try to refer to it, and if we need to go to the actual document, we can. Do you recall there being a document that you referred to in your written testimony in which the plant costs of $583,000 and some change were referred to in the application by what was then the BLE utility for the development of services to James Creek?
Vaguely. I think you're referring to what BLE Development was working with Hisco. And are you referring to some of a cost reimbursement from BLE Development?
Well, you referred in your testimony to the 2011 application of what would become Hisco to serve the James Creek area. And in your testimony, you specifically noted the cost of the plant, which was
583,000. My recollection on this issue was if Hisco, our contention was if Hisco ever envisioned the developer, which was BLE Development or any successor in title, or any buyer in the ordinary course of business, to pay to Hisco any fees like the tap fees, or the allocation of the plant cost for that subdivision, there would be an agreement, a written agreement. But in this case, there was self-dealing because Mr. Laws was managing Harkers Island Sewer Company, Hisco, and Mr. Laws was dealing with himself and BLE Development as developer. So our contention was if there was ever any intent or agreement that whether it be the development or the individual buyers would participate in the cost structure of the equipment installed presumably by Hisco, we would have an agreement to that effect, and we did not have one.
your interpretation. I just want to make sure that I understood you correctly. Your interpretation, when you saw that document during your due diligence, was that if there was further development needed to provide capacity, that there would be an agreement between you in the role of developer?
No. Number one, when you refer to that document, I don't know what you're referring to. What we're contending and what we're saying, which we think is logical, is if there was ever originally any vision, intent, agreement, foresight that Hisco would somehow be paid or compensated for the $583,000 worth of equipment, there would be you went to law school, statute of frauds. There'd be something in writing to that effect. And there was nothing. So that's all I remember about that issue.
No further questions for this witness at this time. Thank you.
All right, redirect.
Yes,
Ex-
please.
Excuse me, I forgot, Ms. Holt.
I have no questions.
No question, okay.
Rebuttal.
All right, now redirect.
Very briefly, Chair Brown Bland. Mr. Timberlake, is it your understanding that any new plant to be constructed within the within the James Creek subdivision would serve the initial 22 platted lots?
Rephrase that, restate that.
Was it your understanding that the wastewater treatment facility to be constructed as planned within the James Creek subdivision, was that plant going to serve the initial platted 22 lots?
No.
What was your understanding?
Our understanding was, in reading the permit and the documents that were publicly available, was, and I think it was, I want to say WQ 23024, that the actual construction of an on-site collection system in the platted area, it was a future site, was the third of 3 phases of the development of an overall system that would have we would have been, James Creek would have been served by West Bay Treatment Facility, which I may have it wrong, but I think Mr. Laws or Hisco purchased that first prior to purchasing its now main facility. To my knowledge, West Bay has been permitted, but has never been constructed or operational. And so we understood that it was going to be what James Creek was going to be served by West Bay is, I think, phase 1 or 2. And then the third phase, which I believe we envisioned as a on-site collection system for the expansion of phase 2 of James Creek.
So it didn't bother you that the wastewater treatment facility had not yet been constructed?
Oh, no.
Those are all my questions.
All right, commission has a few questions. Mr. Timberlake, a minute ago, you answered Mr. Janess that you did not consider MRT to be in the shoes of the developer, recognizing that you're not sitting here serving as your own legal counsel. But could you expand and explain more of why you don't see that MRT is in the shoes of the
MRT is
developer?
the owner of a development. Okay, the infrastructure is in. The subdivision, James Creek Phase 1, it's a gated community, the pavement's in, I think it's connected to electric. The water is offered by Harkers Island Sanitary District, and we can connect at any point. So there's really nothing left to do that an ordinary developer would do for the 22 lots. I think it's 22 lots. There's really nothing left to do except either put a septic, connect with public utility, or have septic tanks, which are not available, not capable of doing. Our issue was, now, if we began to develop the 30 acres, then we would step in the role as developer, which we're prepared to do. But we're here as owner of the property, not in the capacity as the developer of this property. This property's been developed. It's there, it's ready, but for the foreclosure, it would have sewer.
And that would be prior to there being customers on the property to receive service. Is that what you mean?
Could you restate that?
Well, there are no, is it correct that with regard to the 22 lots that has been referred to here, that there's not currently anyone on the 22 lot prepared and ready to receive who needs sewer service?
Therein lies the problem. This is a complicated situation, as Mr. Irby referenced, from a legal standpoint. Carteret County screwed up royally. They should have never platted this without a performance bond. There is no performance bond. Because when you certify a plat and you report a plat, you're representing to the public that utilities are in place, sewer's in place, and will be served by Harkers Island Sewer. Mr. Laws certified that. BLE Development certified that we have electricity, we have water, we have sewer. Mr. Laws certified that as developer for BLE Development. It's our understanding, unfortunately, the person who certified this from the planning department at Carteret County, it was their first plat that they recorded. We've attempted to contact Carteret County and Carteret County's attorney to understand why there was no performance bond required if the connections and then if there was further work that was required. They would not return our calls. I think they understand they have a problem, but we're not looking at Carteret County as liable. You guys forgot more about these issues than I'll ever know, but the best that I can tell, if something happens to this system, and we all know it's in life cycle. What happens? Well, what we think will likely happen is you'll have to appoint an emergency operator, which would likely be the Carteret County Health Department, and then they're going to either have to condemn however many customers' properties, or they're going to have to fix the system. We want to fix the system. We want to help the island. We want to serve our own property. Financially, we're capable of doing all these things. But when you are dealing with somebody who will not adequately respond or cooperate or provide information, or basically you just feel like you either buy a new system or not. That's why we're here today.
So with regard, you say, like, for example, the electricity service is in place.
It's connected, but bear in mind, see, we cannot go to the Carteret County, nor can the other buyer of Lot 49. We can't get a building permit.
So the property is not being serviced by the provider at this time?
There's nothing to serve. It's just a bunch of vacant lots.
All right.
And we cannot get a building permit issued by the county.
And so with regard to the sewer, I believe you testified that but for the foreclosure, there would be sewer service
Yes, ma'am.
there. And my question was, that's your testimony, notwithstanding that there's no, that property is not able to receive service at this time because there's no one on that property that needs sewer service.
There cannot be anybody on the site that would want sewer service or that would require sewer service because we cannot get a building permit to construct anything. Sewer was run right up to the property, and the infrastructure to make the connection is throughout the existing road work. So the infrastructure is there. It's paved and everything is ready to go. The connection has to be made to what I presume was going to be the force main, originally to West Bay, but now it would be to what I call the Harkers Point site. But this is the trap that we're in. We're between a rock and a hard place. Is we cannot make any improvements to this land.
What do you need now to show that there's sewer service there that you don't have?
We have to actually have sewer service.
All right, and that entails what from your point of view?
From our point of view, we are in the Harkers Island. Mr. Laws is the individual on behalf of Harkers Island Sewer Company that came to the Utility Commission to bring in the James Creek territory, phase 1 of James Creek. So we're in his territory. We're in the Harkers Island Sewer Company territory. Okay, as such, that coupled with the plat that's recorded at Carteret County impliedly certifies or directly certifies to the general public, you have utilities. Okay, we don't have utilities. We don't have sewer service. At the time that when the bank foreclosed on the property, at some time prior, there was some septic capacity on the platted future development area where a septic system or systems could have been constructed. The property unquestionably was timbered, presumably by Mr. Laws. And we have a report from our engineer that I believe is in one of the exhibits that says it rendered it unable or incapable of now putting in a septic system. So this is very frustrating for us. We just want to do what's right. We don't mind paying our fair share, whatever that is, provided that figure comes from a verified source, an independent source. We do not trust anything that Hisco tells us. We do not, we're fairly sophisticated people. We have engineers. We're financially stable. We do not have to borrow money. We can develop it. We're happy to fix it, but we do not want to pay for all of our capacity, fixing the system, and his existing customer base and additional capacity. So we're ready, willing, and able to help. We just don't know how to do that when we have a counterpart that's saying, build me a new system.
Can you explain, a minute ago you said you could not get a building permit? Why is that?
You cannot get a building permit from Carteret County if you don't have a septic permit to go with it, or a septic or a tap. So the county is not going to issue a building permit unless you have public, unless you can show to the county you have access to water, which would be through a well, a private system, or public utility, and sewer, which can be through a septic tank permit or a public utility or a municipality. And electric, which can be a municipality, a county, or, a private source.
And what you're missing now is the ability to have a tap?
Well, there are no taps left.
Right.
He's exceeded his capacity, and there, in one of the permits, and I fail to recall the specific one, there were a certain amount of taps specifically allocated to James Creek Phase 1. Those were subsequently sold to, or redirected or assigned, whatever the right term is, to another project.
All right. You mentioned the part of your concerns and lack of trust when it comes to Hisco, concerns not being able to get information. What discussions have you had with Hisco? Have you asked and made these requests?
I have probably individually spoken to Mr. Laws on one or two occasions by phone. We were here in a mediation, I think April of last year, through our attorney, who was also the attorney for our predecessor in interest. We've made various attempts of, well, what about this? What about that? And the standard response we get is, no, it's going to cost $1 million.
Do you know whether in the course of this proceeding or otherwise, MRT made specific requests for the information that you say you need in order to be able to trust Hisco?
We have specifically asked for, I believe it's an allocation of, for this $1 million or 1.1, whatever, what portion of that is to serve your existing customer base versus to add the capacity or the additional capacity required council referred to is there's permitted capacity and then there's like what I call operational capacity or actual capacity that's functionally available.
And what was the response?
We
of
didn't
the
get one.
response? Just no response or refused to answer?
I don't recall anything. We've never gotten any kind of allocation. At one point, Mr. Laws, and I believe he contacted my partner, Mr. Reagan, and said there was a reconditioned system down in Wilmington that was approximately, I want to say 580 to $600,000 that would fix everything. And I'm oversimplifying, overgeneralizing. And told us the amount. Well, we went to the actual owner and found out the price was not what he represented it to us. And we looked at the potential to buy it, to the freight and the installation. But we abandoned that because the problem was it was going to have to go onto his footprint, his existing property. And we're prepared to spend whatever is reasonably necessary. We're not prepared to give him that money and entrust that it'll be done.
How do you propose to find out what's reasonably necessary in terms of cost?
Our engineer, we have a pretty good idea about what we think and believe. He needs to go in to confirm and do his actual due diligence, look at the existing plant, look at the system, make sure that the equipment necessary to upgrade, whether it's just to serve the 22 lots, whether it's to serve, it's all depends. And I'm not as familiar with the technology, but what he generally said is he felt like, and so in fact, I spoke to him this morning. He felt like for $250,000, the system could be upgraded, but he could not confirm that until he was on site. That's why we requested the ability to have somebody actually go on site, do the due diligence.
Have you
know.
made that request prior to today of Hisco? To have
Actually,
access,
so
to allow
I think
your engineer access?
We had a prior engineer, a gentleman named Dan Pritchett. I don't think we've actually ever requested somebody go on site because, once again, it was a moot point. He wasn't interested in anything about serving James Creek. He wanted a new plant.
Did Hisco say to you, or Hisco's representative say to you that they didn't want to serve James Creek?
Verbally,
Yes, expressly.
they at no point could serve us because the connection wasn't made. We would make the connection, but there were no taps. There was no capacity.
Did they indicate if they did not have funding, or did they indicate if they did have funding, or if MRT provided funding, that they would not serve James Creek?
Not in so many words. It was just, we're not going to, the statement we always were presented with is, you're a developer, which we're not in this case. You have to pay for your capacity. Your capacity cost $1 million.
So as not a developer, you've said in this situation, you're not here as a developer, and at least with regard to the 22 lots, am I correct? You're not a developer?
We own 22 lots and we're seeking to have those lots served by the public utility within which the territory that we're in, by the member manager of Harkers Island Sewer Company, who was also the member manager of the BLE development that developed the certified plat of the 22 lots that we purchased.
So is it your position that as to the 22 lots, MRT, not being a developer, does not need to make a contribution towards the sewer facility?
No, that's not my position. I think to clarify my position, I think and we believe, and this is just our opinion, that the original plan was probably, since he was wearing two hats as both developer and Harkers Island Sewer Company, I think what he intended to do, or what we would have done, is if we were going to put all this infrastructure into James Creek, okay, you would want a means to get reimbursed over time on the sale of the lots. That's what we would do as a developer. There was never a written agreement, and which is inexplicable to us because it's the same guy dealing with himself. Why was there not an agreement? Why did you not have an agreement between BLE Development and Harkers Island Sewer that you're going to install this infrastructure? He could have deeded to himself, to Hisco, the future development for the on-site wastewater collection at any point. And
Right.
that never happened.
For our purposes today, does the lack of such an agreement indicate to you that Hisco should cover those costs?
Let me just say that generally, we're prepared to pay our fair share of the cost to whether it's the 22 lots, the future development. We don't have a position. We're not trying to get, water out of a rock. There's no capacity. And so there's no taps. So we're going to have to pay for it. We're ready to fix our situation, his situation, the island situation. But we do not want to pay for anything for his existing customer base or additional capacity over and beyond what we will utilize either in phase 1 or phase 2 of our development. We're happy to pay for all that.
So my question goes back to asking and seeking access to whatever wastewater treatment plants are involved here. There might be possible options for service to James Creek. Why wasn't there a step made to seek access by your engineer to do whatever study needed to be done to be able to cost out or even suggest different options that you might be able to present that to Hisco for their consideration?
Because it was a moot point.
Well, why do you call it a moot point?
Because he's got a system at the end of the life cycle, and unless we paid for the whole shebang and fixed his problem, we weren't going to get service. And that was very, very apparent to us. So we're not going to spend money, to answer your question, we're not going to spend a lot of money on an engineer to go do a site assessment, evaluation, analysis, when we know it's a moot point.
Well,
Because
aren't you asking for that today?
no, I believe what we're asking for today is a myriad of things. We are asking for the opportunity. What we're doing here today is bring the issues to a third party and let an objective, knowledgeable third party look at both sides, look at the law, and tell us what you think. And what frustrates us is this was filed originally by the bank. I can't even remember if it's 3 or 4 years ago. We're asked in April of last year, to mediate. We're going to do anything and everything reasonably possible to get this resolved. It took about 5 minutes to realize there was no good faith effort to mediate. And then we're put off till July of last year. Right before we get ready for that, he's going to sell the company. That proved to be another, in our opinion, delay.
Let me ask you another way, Mr. Timberlake. Was there ever the MRT or any predecessor present any counter or evidence of other cost figures besides those that Mr. Laws presented to you or presented to MRT?
I can't say for certain. I believe we shared some information from our engineer, Dan Pritchett. Gosh, I don't know, it'd be 12, 18 months ago. And
Would you have anything in writing that showed what that might be?
I, I just don't
Or your
recall.
engineer?
I think it was communications between council and information that we had gotten from Mr. Pritchett about what about this, what about that, and it was refuted. There is a complexity here that y'all will probably understand. I don't quite grasp, but it's my understanding that if the effluent is subsurface versus above surface dictates whether it falls in DWQs or DHHS and the permits, and I don't understand how all that works, but there's evidently, some confusion there as to which permits and how things work. So this gets confusing to me, but I think we have offered some general solutions, but we just always been, no, that's the cost.
Mr. Irby, around here, we do receive what we call late filed exhibits. And I'm requesting that if you and your client discover that you have some evidence showing either options offered or cost figures presented to HISCO, that you provide those to the commission as a late filed exhibit at a later time.
I will look for those communications. I don't have a specific recollection of a formal letter. There may be some informal emails about some of these figures, but I would need to go back and look,
All right.
Madam Chair.
And I'm just asking if you have those, that you please present them to Mr. Janessa, and he can look at them, but also file them with the commission as a late filed exhibit. Mr. Timberlake, so the public staff has recommended that the cost of the wastewater treatment expansion to serve James Creek be shared among MRT and HISCO. And they recommend, based on a stipulation in another docket, which was 1297 sub-0, that MRT pay 50% of the expansion cost, that 30% be covered in tap fees, and that HISCO invest the remaining 20% to be recovered in rates. Is that something that MRT is agreeable to or has thought about?
Oh, yeah, absolutely. Yes, ma'am.
So, yes, agreeable
Yes, ma'am.
to the 50% and the 30%.
Yes, ma'am.
All right. Have any lots within the James Creek service area been sold to potential customers?
Mr. Law sold, or BLE Development, I believe, sold one to, it's lot 49. I can't recall the purchaser's name.
And has any customer, to your knowledge, been denied a building permit due to
I believe
lack
he
of service?
was, but I'm not sure.
Is that the only one that
Yes, ma'am.
you were aware
We
of?
knew we couldn't get one.
All right, and does MRT have any customers who are ready and willing to purchase lots in the James Creek service area now?
We could sell the 22 lots. If we had the permits to serve the property, we could sell all 22 lots very quickly.
But you don't have that ready and willing buyer as we sit here today.
Yeah, I think we do. We have a myriad of people that would buy the lots as a whole, but we're not going to represent to anybody anything other than the actual facts. And right now, they're unbuildable because you can't get a building permit because there is no sewer. if we had sewer in place today, in this market, we could sell all 22 lots before we got back to Lexington.
And just a follow-up to an earlier question about the recommendation of the public staff. Have you had opportunity to discuss that with Hisco, the public staffs? Or had occasion, I should say. Have you had occasion to discuss the public staff's recommendations with Hisco?
No, ma'am. I mean, we have not communicated since this is in kind of the commission's, I don't think it's appropriate. We don't have regular or normal communications going back and forth with Hisco because we're not an existing customer, we're not an account, and it's kind of awkward. We don't have anything to talk about. So we've just really kind of patiently waited for this process to evolve and unfold so that we could know where we stood and what to do.
Madam Chair, if I may, I've instructed my client to not communicate with Harkers Island Sewer Company since they were represented by counsel. So a lot of these communications took place between myself and Clark Wright.
All right, thank you for that. And I'll just say in a general way, where you both can hear, it's just almost standard for me to say, or my motto, that the solution that the parties come up with themselves is probably better than the solution, and you'll be happier with it than the solution that the commission might impose. But that, notwithstanding that, is absolutely your right to come here and seek answers from the commission. So, other commissioners, Commissioner McKissick.
Yeah, I have just a few questions.
Yes, sir.
As it currently stands, you own the 30-acre tract as well as the 22 lots. Is that correct?
That is correct. And then we also own about a 2.6 acre tract across Oak Hammock Drive that has we own 9 of the 10 boat slips,
Okay,
and that's part of the development.
all right. Now, when you acquired, I'm going to refer to them collectively as the properties, were you aware at that time that this lot that the original wastewater treatment plant would have been built upon was a property that you were acquiring that wasn't going to be owned by Hisco?
Yes, sir, we were.
Now, at that point in time, did you go out and do any due diligence to find out how the existing lots were currently being served?
They were not being currently served, and we were aware of that.
You were aware of that.
Yes, sir.
So you knew they were not being served at that time.
However, we were also aware that the entire subdivision was in the territory of Harkers Island Sewer Company. And we were also aware that we could not do individual septic tanks on the lots. So therefore, and we originally asked to be removed from the territory, and Mr. Laws refused. And so we were stuck in purgatory. We were in a territory, we couldn't do anything, and he wouldn't let us out.
So you asked not to be served by Hisco.
We asked to be served by Hisco.
You asked to be served.
Yes, sir.
Okay, that's what
And the standard response we get is, it's going to cost, you're a developer, you have to pay for, your cost of providing the capacity. It's going to be $1 million.
Okay. Now, you indicated that Carteret County would not allow or issue septic permits.
Carteret
you?
County.
And let me ask this. I'm trying to understand what kind of communications you had with them, because I understand that you felt like they wouldn't issue them because the property had been logged or timbered. But I would also assume that there's certain lot size requirements or absorption rates of the soil that have to be met and satisfied. So can you explain to me exactly what Carteret County indicated to you when you approached them about the potential of using septic tanks?
Carteret County certified the plat. So the plat is recorded and anybody can pull it up a public record. So they're well aware if it's very difficult to educate somebody, whether it's in the building permit department, the zoning department, explain this unique situation. I've never seen it before. I hope I never see it again. But you've got an existing plat, and if you look on the plat, it says Harkers Island Sewer Company is going to serve sewer. Harkers Island Sanitary District is going to serve water. I can't remember who serves the electric. Everybody signs off. Planning director signs off. It's certified. When we go to get a building permit, you either have to have a septic permit in hand or a septic tap. In this case, if they look at it, they're like, well, you need a septic tap. Well, we can't get a septic tap. So by default, can we get a septic system on
Mhm.
each individual lots? We had a soil engineer go in, and I can't remember his name, but none of the lots, the whole reason Mr. Laws put the infrastructure in there is the site will not perk. So it's you can't get a building permit without one of those two requirements, and we can't get either one of those requirements, and we can't get a tap despite the fact that we're in Harkers Island's territory because of either capacity issues or there's no taps or we don't have $1 million to buy a new system to rebuild his existing system. So
Okay. And let me ask you this. So the communications you had with Carteret County were based upon the fact that you did not have a sewer tap at the property that could be provided by Hisco, and the land would not perk after you had an engineer go out, and a soil engineer, and test the soils.
correct, they can't issue, they legally cannot issue one without those requirements.
That the person that you sent out was like the soil engineer, did they consider replatting the subdivision so that it would allow for septic tanks to be used if perhaps it was related to
We
that
have,
factor?
we have since purchased, in addition to the 30 acres, another what, 4, 5 acres, 3 acres, adjacent that, to where we can get I think 2 or 3 septic permits there. But if there, it's not feasible, it's not possible on the 22 lots or on the 30 acres. And there was, uh, prior to being timbered, there was probably not much that could have been done on site. But after it was timbered, there was nothing that could be done.
So the timbering that you referred to had really negligible impact in the ability for the land to perk and be served based on.
Negligible is a relative term in the sense of it did not eliminate very many spots that would perk, but some is one heck of a lot better than none.
Okay. And did you give, so it sounds as if you relied upon the representations on the plat to your detriment.
No, sir. We walked into this with eyes wide open. We understood the situation. We understood initially and to today, we're going to have to contribute to fixing this problem. You've got a volcano down there and it might go off next week, next month, next year. It might be 3 or 4 years, but it's going off. And when it does, now the simplest thing for us to do is just sit back and wait.
Okay.
And because we're in the territory and if we need to wait 10 or 15 years, but that doesn't help the island, that doesn't help us. We want to develop the rest of this property. We want the 22 lots served. We're willing to pay our fair share. We don't want to buy a whole new system for the existing customer base and walk away with a lot of future capacity, and just give that away free of charge.
Okay. And I believe in response to Commissioner Bland's question about the proposed allocation of costs made by the public staff, you indicated that those allocations were numbers that you found to be acceptable.
Yes, sir.
I guess the question that in my mind remains open is who would make the determination as to what would be necessary in terms of infrastructure improvements to provide the capacity for these 22 lots at this time? Would you agree with that assessment?
We would only trust an objective third party.
Someone who is an engineer, I assume,
Yes, sir.
would make that determination
Yes, sir.
as to the 22 lots, but not as to the remainder of the tract.
Both.
Both.
Yes, sir.
So as it relates to the remainder of the tract, which I guess is 30 acres, how do you contemplate that that would be developed? And when I ask that question, how many additional lots do you think would be created? Or I would assume single-family homes that would be a certain number of bedrooms that might determine how much additional capacity is needed, not simply for the 22 lots, but to develop the remainder of the tract which you currently own. Because that's something the engineer would need to know in making an assessment as to what infrastructure capacity would need to be created to adequately serve the development that you reasonably anticipate.
Yes, sir. And the good thing, Carteret County has already approved, I think it's a total of 80 lots, which would include the 22 or 23 in phase one. And I think it's an additional 57 lots. So that information is available. Now, from MRT standpoint, we do not have specific plans. We take things incrementally, step by step. And the first step is resolving this issue. There's really nothing else we can do until this issue is resolved. And so it's a moot point to spend a lot of money on engineers, soil scientists to look at all the myriad of options. But we have looked at taking the existing 22 lots, purchasing the one lot that we don't own, replatting it and having 5 home sites. And that's all there is on the existing site and the 30 acres, all the way to let's develop the 23, if we get service on the 23 lots, we'll develop the other 57 lots for a total of 80. We'll replat the whole thing and do 150 lots for an RV park. Or we put the whole thing in a conservation easement. My partner's a certified an appraiser, and he does a lot of conservation easement. So we've looked at a myriad of different scenarios, but it's a moot point to speculate because we just don't know what the costs are, what the options are, nor have we had the ability to evaluate those adequately.
Okay. So I take it that at this time, you're concerned about the 22 lots and the one additional lot. That would be
23.
23 total.
Yes, sir.
that is of immediate concern in the near term?
Yes, sir.
And that as it relates to the balance of the property that's there, it would be your thoughts that once development plans are more clearly defined, that you would potentially seek service for those areas as well. But if you use this as a conservation district, you don't need any service.
That's correct. At that point, to Ms. Brown Bland's point, we become the developer
Yes.
and we ascertain, evaluate, and analyze what are our options. And I just can't honestly answer what that could be. I have 3 other partners in this venture, and we really hadn't even given any thought because it's a beautiful island. It's kind of stuck in time. We've tried to be very respectful to the the inhabitants, the citizens and residents there. They don't like change. I mean, this is an old fishing community, and so we do not want to rock the boat. We just really, we haven't been in a position to really give this any serious thought. Our immediate concerns, the 22, 23 lots. The second priority would be what are the options for the additional 30 acres? And we're willing to do what we need to do to help the island, to help our development, to help HISCO.
I understand. I think the thing that occurs to me is that assuming there's an objective engineer doing this assessment, it might substantially impact projections on cost and infrastructure improvements, depending upon whether you're serving 22 lots or it's your habitual intention to serve perhaps 80. Because certain things might be done infrastructure wise in the near term that provide that capacity for the 23 lots, but it might not be as cost effective to take that approach if you're looking at expanding to serve a substantial greater capacity, depending upon what you do with the remainder of that tract.
My understanding of the technology is, in our current situation, is phase 1 is in the territory, but phase 2, or the undeveloped, is not currently in Harkers Island territory. So I think we would have, the dynamic would change even if phase 2 is in the current territory. We are asking for relief today to be able to opt out of the territory, whether that would be all our property or one specific or 2 specific, because we can't predict what your ruling will be. And so we just have to look at a myriad of different options. And so we actually turn into a developer on phase 2. And at that point in time, I think we have to go to Harkers Island Sewer Company, arm's length, and say, what's it going to take do you have the capacity? Do we have to increase the capacity, or there is no capacity? And that in turn will dictate whether we do a conservation easement, no development, some development. But with respect to the 22 lots, it's already in the territory, the infrastructure's done. It's been certified to the public that utilities are in place. The county certified that, did not require a performance bond, and unfortunately, they're not in place, and which prevents anybody from getting a building permit.
So you would like this commission to focus upon providing relief as the 22 or 23 lots at this time, and leave open the issue as to what may happen with the balance of the properties, because you may want to opt out, as I understand it. Is that correct?
In general terms, I'd really like the commission's determination and feedback as to how to resolve all these issues. And whatever you come back with, we're going to be fine with. I just want decisions to be made so that we know where we stand and how, if at all, to go forward.
Thank you. I have no further questions.
Commissioner Hughes?
Yeah, thank you. Just, I think these are follow-ups, really. A lot of moving parts here. So I apologize if I get something wrong. Um, but the numbers, I'm a numbers guy. You mentioned a number and you were pretty adamant that it's going to cost $1 million. No, I mean, that's the impression I got. That was that $1 million for, or was that response for the 23 lots or the 23 lots plus the additional one? And maybe I misunderstood you, but that I was just trying to link that answer
To get
to
any
this.
service,
Pardon me?
to get service.
Okay, so that would be for the entire, everything you own, not just the 23 lot.
I can't answer that. I mean, it never got to that kind of level of detail because it was apparent the $1 million was not to serve James Creek. The $1 million was to replace the existing system.
Okay, and then thank you for that. And then the other adamant response, it seemed to say, was that the terms of the public staff's settlement, that you seem to be positive about that with the 50%. Was that settlement, was your kind of agreement with that settlement, again, for the 23 lots, or was it for the entire area?
Either or.
Okay, either or.
Yeah, it doesn't.
Okay, so either or.
Yeah, and logically, that's going to be subject to the respondent, because I presume they were picking up a certain percentage and, our focus right now is 22 lots.
Okay.
The existing platted subdivision that we own.
Okay.
That everything that's already developed.
Okay, so the 50% for I know it's either or, but the first part of the either 22 lots, if the cost, you'd be willing to do 50%. I think Commissioner McKissick said this. We're all struggling with trying to pinpoint costs these days, and I realize that, you all know better than us how all the moving parts of trying to predict costs, even with engineering estimates. But does that 50% have approximate caps in your mind? That 50%, is it 50% of 2 million? Because that's $1 million, $1 million.
That's not a problem.
Okay. So
But
there's
but
not.
it
Okay.
does, but our agreement doesn't have caps,
Okay.
but it does have conditions. We're not paying Hisco. We will pay an independent third party.
Yeah.
We will pay direct, but we will not entrust money going to Hisco to determine how it's spent.
Okay. But there's not, in your mind, there's not, because if you go back to the original agreement, 8 or 9 years ago, there's much more modest numbers that now I think are.
It's our understanding, and I believe very firmly there's a gentleman that we've been working with who is a representative of a company called Aquapoint, and they're a manufacturer of systems in the Northeast. He grew up on Nags Head. He lives in Asheville. He strikes me as brilliant, and he was familiar with this system because, and actually has come to the system at the request of Mr. Foreman and Mr. Laws long before we ever got involved. And he chose not to get involved at that time, but he's familiar with the system, and he's pulled up the public record. And Mr. Reagan and I have met with him a few times, and he says the system can be fixed. There is technology now, and there's a way, and I may not use the right terminology, but there's a way to transition through compartmentalized equipment and advanced technology to utilize, either fix the existing system or redo the system on the existing footprint. And the numbers he gave us, I spoke to him this morning, were kind of updated for inflation. And so we understand what the approximation is.
Okay. And those were numbers, again, just to be clear, those were numbers for the 22 lots or he said it didn't matter.
He gave me a range for 22 lots plus additional capacity, and that's to be determined.
Okay, and that I won't ask you for that. I know it's preliminary and but how you did the math in your head, and half of that seemed.
Oh, I didn't pass out, no.
Okay, thank you. We'll leave it there. We don't want you to pass out. Okay.
So, Ms. Timberlake, I believe public staff indicated that the Department of Human Health and Services, who permitted the wastewater treatment plant known as Harkers Point or Harkers Village, would need be able to serve an additional 40,000 gallons per day just to serve, I believe, the entire 80 lots that are known as James Creek. Do you take issue with that?
If that's Mr. Berkowitz, I take no issue with it. I'm sure it's correct, whatever they said.
And so if the expansion is for an additional 40,000 gallons per day, and the cost were limited, the additional cost, the cost of expansion were limited to those 40,000 gallons per day, indicating that that's service for James Creek, not service for other existing customers per se. Does MRT take issue with funding that? To the
I don't know how to answer that question.
to the percentages that you earlier said would be.
I don't know
Okay.
how to answer that question, because you're getting into nebulous territory as to, are we fixing the entire system? I don't know how you can pinpoint or allocate specifically, it's going to cost X to add a capacity. I don't think it's as simple as that. I don't think, my understanding
If
of.
those costs could be determined to some reasonable
If
degree.
those costs could be determined, and we could be assured that we could pay our percentages into the commission or directly to the manufacturer of the equipment or the installation company or whoever, we have no issue with that. But as we all know, the devil is in the details. And I don't think it's as easy as you can spend X amount and add capacity. I think it's just the existing system is going to have to be upgraded and fixed for the existing customer base.
And with regard to paying Hisco, you're familiar that the public staff's recommendation was that the MRT would place money in escrow?
I believe I do recall that. Yes, ma'am.
Is that an acceptable approach?
Yes, ma'am.
All right.
It provided that's not, there again, this based on the details. We'll put money into escrow. We don't want to leave it there, for an undetermined amount of time. Once it's put in there, we want to know that there is a schedule and that the process is going to move forward and move forward quickly. And we're hesitant to invest any money where in any way, shape, or form, we're dependent upon Hisco to do this.
Mr. Janess, do you have questions on the commission's questions? Wait just a moment, Ms. Commissioner McKissick.
I just had one quick follow-up. You identified an engineer up in Asheville. Is this an engineer licensed to practice in the state of North Carolina?
Yes, sir.
Would you mind disclosing his name or her name?
I would not at this point in
I
time
understand.
because
Okay,
I
that's
spoke to
fine.
him and said I would not.
Okay, that's fine. Thank you.
All right, now, Mr. Jeunesse, questions on the commission's questions?
Thank you. Mr. Timberlake, did you ask for any allocations of the available capacity at any point in your ownership of MRT?
Personally,
Yes.
no,
Do you know whether any request was made?
I'm not aware.
What would it take, to your understanding, for a building permit to be issuable on any of the lots that you have in James Creek?
They cannot be, they will not issue one.
If you received a will serve letter,
I'm not aware.
have you asked Carteret County what it would take to get a building permit as far as documentation from Hisco regarding service?
It was a moot point. We couldn't get a building permit.
Why is it a moot point?
Well, when
Yeah.
Carteret County says you cannot get a building permit without a septic permit or a tap, I think it's kind of fairly moot after that point. So we're not going to go spend a lot of time, energy, and effort when we know there's no capacity and there's no taps, and we're not going to spend $1 million to replace the system. So
But on each lot where you could get a tap, where there was capacity to provide service, you could potentially have a building permit, correct?
in theory, yes.
Have you had the lines and meters and other infrastructure that is in place in James Creek pressure tested or otherwise checked by your engineers for their ability to be hooked up to Hisco's water treatment?
Once again, it's a moot point if Hisco's not going to serve the subdivision. And we're not going to go through that expense. If you don't know anything about development, that's not cheap. Okay, so we're not going to spend a lot of money on soil engineers and infrastructure engineers, utility contractors to go in and test something that we can't use.
Is it your testimony that you did not at any time ask for a breakdown of the number that was being presented to you? The one that keeps getting mentioned is $1 million, that you did not ask for a breakdown of where that money would go?
Oh, we did ask.
Okay.
I think that was between council of tell us what the costs were and how they were going to be allocated with respect to the existing customer base versus the James Creek, the additional capacity. But we get moving chairs responses of, well, West Bay's not constructed and we got to construct this, and DHHS and DWQ and this permit and that permit, and we had to go do this for the RV park, and they paid for this additional capacity where our permits went. So we never felt like we got a straight, coherent answer on anything.
As to the question of whether
We never got a breakdown, no. Let me rephrase that. We never got a breakdown that we trusted, that our engineers looked at and said, that's right.
so you did get a breakdown, but you didn't like it.
we got information. I don't know, you call it a breakdown. We got some general response. We never get anything of a specific factual or fact-based nature. We never got any response to my knowledge about that, other than the figure tended to say the same, million, million one, million two. But I don't remember ever seeing any responsive document, statement. I mean, it's like tacking Jello to the wall. I could never figure out what they were and were not saying. But bear in mind, I do not understand the details of the technology involved. I freely admit that. But I trust the engineers that were looking at that same information and what they were telling me.
And is Aqua a provider of wastewater treatment facilities that you would trust?
Aqua is a public utility that's licensed in the state of North Carolina. Aqua Point is a manufacturer of equipment. They're based in the Northeast, I think, Boston maybe. Or actually, I'm not sure where they're based.
You mentioned that the preliminary plat shows 80 lots, correct?
We understood, and I'm not sure I think I've seen a preliminary plat. We understood that there was preliminary approval for a total of 80 plus lots, but I don't remember the specific details.
Do you know whether those lots outside of the original 23 in phase one were the same size as those in phase one?
No, I don't.
What would you say is the value of each of the lots currently in phase one if they're served with sewer?
I think that's an irrelevant, nebulous opinion that can vary widely. So I don't understand the point of the question.
Well, approximately, what would you say?
As is,
Yeah, with sewer.
I wouldn't put a value on it. I mean, I don't know how to answer that question. I'm not an appraiser.
But your partner is, right?
Yes, he's an appraiser.
All right, I'll ask him. I don't have any further questions for this witness at this time.
Ms. Holt, questions on commission's questions?
I do have one. Mr. Timberlake, I'd like to follow up on the commission's questions regarding what I think they were referring to as the public staff's modified recommendations of December 9th,
Yes, ma'am.
2021.
Yes, ma'am.
And you stated that MRT-1 is agreeable to the percentage investment allocations of 50% and 30%, correct?
Yes, ma'am.
Are there any terms of the recommendations to which MRT-1 is not agreeable?
Not to my recollection.
Okay, thank you.
Mr. Irby? Questions on commission's questions?
Just one follow-up question. To the extent that the commission enters an order consistent with the modified recommendations of the public staff, would you anticipate recouping any of those funds or any of your investment with tap fees?
That's a good question. If we hypothetically were to contribute, uh, it's our understanding we would at least get credit for the taps, the $2,500 per lot tap. That we would, if we had to do $500,000 and there was 80 taps, we would be able to walk away with 80 taps, which is the equivalent of $200,000 in value. If I understood it correctly.
Those are all my questions.
All right, Mr. Timberlake. Well, before you leave, we'll take motion from you on the exhibits.
Yes, Your Honor. Just to clean up the record, we've previously referenced exhibits A through L. I'd move that the exhibits identified that were submitted with Mr. Timberlake's direct testimony as exhibits A through L be admitted into evidence.
All right, without objection, that motion will be allowed and MRT Timberlake direct exhibits A through L will be received into evidence at this time. Now, Mr. Timberlake, you may be excused. Give me just a moment. All right. We're gonna we're off the record for a minute, Joey. We're gonna end up taking a break. Taking a lunch break at 12:30. So I'm gonna go ahead and let them put up their next witness, just giving you an idea where we're going. And I'm sure he'll still be on the stand when we come back probably at this point. All right, back on the record, Joey. Mr. Irby, call your next witness.
We call Tim Reagan.
Do you solemnly and sincerely swear that the testimony you're about to give should be the truth, the whole truth, and nothing but the truth, so help you God? All right, you may be seated, Mr. Irby.
Would you please state your name, position, and business address for the record?
My name is Tim Reagan. I live at, and my business address is at home. It's 138 Lamb Drive, and that's Lexington, North Carolina. I'm a member and manager of MRT-1, in addition to Mr. Timberlake and two others.
Mr. Reagan, on February 26, 2021, did you pre-file direct testimony consisting of approximately 8 pages?
Yes,
If I were to ask you those same questions today, would your answers be the same?
not entirely.
What corrections to your testimony would you like to make?
I believe on page 4, there was an indication based on some previous documents that we'd received. We thought that James Creek already had the allocation assigned to it. I'm striking that from my testimony. It was not allocated.
Okay. Are there any other changes?
No.
Chair Bland Brown, I move that Mr. Reagan's direct testimony be copied into the record in this proceeding as if given orally from the stand.
All right, that motion will be allowed, and Mr. Reagan's pre-filed direct testimony will be received into evidence as if given orally from the witness stand.
Thank you, ma'am. I tender the witness.
Good morning, Mr. Reagan.
Morning.
Did you have communications with Mr. Laws at any point about securing available taps?
I did, yes.
Were there taps available at one point in your conversations?
Yes, there were.
Do you recall how many?
Approximately 10.
And were those offered to you on a lot-by-lot basis?
Not sure what you mean by lot by lot.
Did you have the ability to request service for individual lots in James Creek?
The offer was, I'm happy to sell you 10 permits at $2,500 a piece if you get a building permit prior to that. that he did not want to just sell an empty permit, not knowing that it was going to be built upon and put into, and so that the sewer would actually be active and put into use so that he could collect fees off of it, which made economical sense, sure.
And under that arrangement, would you have received a will serve letter so that you could get a building permit?
Did I?
Would you have under that arrangement? I take it that you did not, in fact, carry through that arrangement. Is that right?
That's correct.
But you could have received a building permit with a will serve letter from Mr. Laws.
I'm not familiar with that part of the building permit requirement. But I will, if I can expound on that just a little bit. It's without water, without sewer, without electricity, all being active. There's no point in trying to get with a will serve letter or anything else. There's no point in trying to get a building permit, even if I could have gotten it with that, without any active, because we would in turn, we're not builders, we do develop and buy and sell properties. So we would have simply not been able to get a builder to buy those lots, even with the will serve permit, even with the building permit, without actually having active sewer and water, and electricity in the development. No one's going to go build 10 houses and, know that they cannot close on those houses and people get active services and not knowing how long that will take.
If you had paid the tap fee and received the allocation, you would have expected to receive actual sewer service, yes?
Yes.
And I'm not following why you're saying that you wouldn't have service if you built on the basis of an
It's
will
not
serve letter.
connected.
If you pay a tap fee to the sewer company, you would believe that it would be connected, yes?
Well, I believe that, but I also believe that the property had already been sitting there for some time without being connected, I'm also familiar with the capacity issues and with the condition of the existing facility as to whether that would have been possible or not.
We are all familiar with the capacity issues, but at the time that we're talking about right now, you asked if there was capacity and the answer was yes, and you can have it for a tap fee, yes?
With a building permit and a tap fee.
As far as you know, did MRT or any of its predecessors in title ever pay Hisco to reserve capacity?
No.
Did you ever ask Hisco for a breakdown of what the cost that was being proposed for an increase in capacity, what that would represent or where that would go?
No. Most of those negotiations were being handled by Mr. Timberlake and the other partners.
Mr. Timberlake deferred to you on the question of what the value of the preliminarily platted 80 lots would be. Do you know what those lots would be worth if they had sewer on them?
I cannot answer that question legally. As a certified appraiser in North Carolina, I cannot answer your question. I have to have a backup file for any number that if I give you a number, I have to have a supporting file to come up with that number.
What did you pay for the James Creek property?
Total price. 120,000, I think, something like that.
120,000 for all of it?
Yes.
We have no further questions for this witness at this time.
All right, Ms. Holt?
Yes, just a couple clarifying questions. Mr. Reagan, is MRT, what wastewater treatment plant does MRT want to connect to? The Harkers Point treatment plant or the West Bay treatment plant?
It should be Harkers Point because from what our engineer told us, and this would have been Dan Pritchett from Jamestown Engineering, that West Bay, having never been operational, that a sewer plant needs to have water running through it in order to remain operational. And it's been sitting for quite some time, and that it would probably not be functional even if you tried to get it operational at this time.
And MRT is willing to contribute funds to upgrade or expand capacity.
Yes, absolutely. Our pro rata share for sure.
Thank you. That's all.
Within, as long as it makes the entire project, cost feasible. So,
Thank you.
all right.
Redirect?
Mr. Reagan, could you expand on your, for lack of a better term, your explanation of the catch-22 between Mr. Law's offering to sell 10 taps and your inability to purchase or acquire those taps?
Well, I mean, our desire not to purchase them would it be based on the fact that we could not get a building permit, maybe with a will serve letter, if that's available. But if it will serve, then with no sewer connections, there's again no point in us trying to accommodate or trying to acquire those lots or those sewer taps, I'm sorry, without any possible or potential for those lots to be built upon.
If you haven't acquired those taps without Hisco's requirement that you have a building permit first, would that have repaired that issue?
Yes.
No further questions.
All right, Mr. Reagan, with regard to the public staff's modified recommendation, and having heard the testimony of your partner, Mr. Timberlake, do you have anything else to add, or do you take issue with Mr. Timberlake's testimony to us?
No, I don't take issue with any of that. I mean, I'm with him, and I think we are with our other partners as well, willing to accept the public staff's recommendation of the allocation of the expenses related to providing sewer to James Creek. And then the only other, there are 80 lots total for this development. Okay, there were 22 or 23 on the recorded plat from 2013, and then the balance of those 80 are in this preliminary plat that you've heard testimony about. So we really would like to have a plan for sewer allocation as, to the remainder of the preliminary lots as well. Speaking as the one of the scenarios that Mr. Timberlake presented was the possibility of, one option would be to put some or all of the property in a conservation easement. In order to create value for that conservation easement, I am a conservation easement appraiser, and that's pretty much all I do nowadays as far as appraising. And you have to create a before value and an after value to determine what the value of those rights that you're giving up by putting a conservation easement on a piece of property. So if those 80 lots don't have any possibility of sewer or septic, then that value that you put in there before you put a conservation easement on it and the value after, there's not much difference in those two values, because you can't really do anything with the property before you put the conservation easement on other than agricultural use or something like that. Then you just don't create any additional, you're not really giving up a whole lot by donating conservation easement on something that can't really be used for anything other than agricultural purposes.
And with regard to the recommendation coming from the public staff and the percentages of sharing at 50, 30, and 20, that applies to any repair, upgrade, or replacement, correct?
Correct.
Okay. Commissioner McKissick?
Just one or two quick questions, sir. I believe you indicated that you will offer 10 taps at $2,500 apiece,
Correct.
and that if you had acquired those, you would have been able to secure a building permit. Is that correct?
No, we would not have been able to.
You would not have been.
Well,
For
I'm
those
sorry,
particular-
from what I understand from what respondents are saying, that with a will call or will serve letter, I'm sorry, that you could possibly get a building permit.
Did you investigate that possibility?
We're not familiar with the will serve.
You're not familiar with the will serve?
That's
Okay.
correct.
And are you familiar with the process that some jurisdictions use or companies of reserving sewer capacity?
Yes.
And did you explore that possibility?
No.
You did not? Okay, all right. And I believe you said the acquisition price for the 22 lots and the 30 acres was
I think
$120,000
that's correct. That's approximate.
to the best of your recollections? Okay, thank you. I don't have any further questions.
Commissioner Hughes?
Yeah, I'd like a clarification, at least, but it was of your partner's comments, so if you can't do it, you can't do it. But this arrangement, first off, now we're even more complicated because now we have 10, 22, or 80 as different options. But from your personal experience, well, first off, would you be comfortable, as your partner said, with the either or? The 22, because what you just finished saying, it seemed to imply that you were nervous about leaving those, 58 lots kind of out there, but he was pretty adamant that either or would be okay by him.
I'm fine with either or
Okay.
as well. Yeah, I didn't mean to, I'm not nervous about that. It's like, it just naturally creates more value, the more lots you have.
Sure.
So, that's all.
The other thing, I just want to make sure I understand your understanding of this agreement, that you're saying you're okay with it. When it says 50% of the payment would be from MRT and 30% would be from tap fees, it wasn't completely clear in the response that was just presented, but there was a little bit of insinuation that the tap fees would be part of the 50%. And was that your understanding, that if you were responsible for 50%, that would be, you would get a credit from whatever tap fees? So, I mean, just to round numbers, if you had to pay 100,000 and you collected 25,000 in tap fees, you would put those tap fees against that 100,000? Was that your understanding of the?
I don't know that I have that understanding.
Okay.
An understanding of that.
Okay, would your understanding be that you would have to pay the 100,000? I mean, excuse me, you would have to, sorry, you would have to pay the 50%. You would collect tap fees, and that would need to come up to an additional 30%, and then you would look toward Hisco to pay the extra 20%. Is that your understanding of how it would work?
I think that is correct. I haven't, I'm just going to be honest, I haven't really discussed the public staff's recommendation in detail.
Okay.
Sorry.
Okay, so yeah, I realize that. Well, let's leave it at that. No further questions.
Mr. Janess, questions on commission's questions?
My follow-up questions were, I think just very well explored by Commissioner Hughes. The one question that I did forget to ask you earlier was, did you or did MRT ask Hisco to allow Dan Pritchett to investigate the wastewater treatment facilities?
No, we did not. Dan Pritchett was engaged by Pinnacle Bank. And then Pinnacle Bank, as part of our purchase, gave us access to some of his findings.
So as to your information, your predecessor entitled did send an engineer over to Hisco to do some investigation. Is that right?
I don't know the extent of his communication with Hisco. I just know that his job was to research the situation and the status of the sewer plant and the subdivision. But what communications they had, I have no knowledge of.
You don't have any information that MRT or its predecessors entitled were prohibited from seeking information from Hisco.
I don't have any information on that, no.
Thank you.
Ms. Holt?
I have no questions.
Mr. Irby?
Just a couple, Your Honor. Mr. Reagan, when you were discussing the 10 taps that were available with Mr. Laws, were you offered a will serve letter to facilitate obtaining a build permit?
I was not,
Were you offered a shall serve letter to facilitate obtaining a build permit?
no.
What exactly were you told by Mr. Laws?
Just cut and dry. I have 10 permits available still at $2,500 each, if you have a building permit.
That's all.
All right. Well, you made me a fibber. We're going to be done with Mr. Reagan before lunch. Mr. Reagan, you may be excused.
Thank you.
All right, we're going to break now for lunch. Be back at 1:30. Let's come to order. The commission is going to take a recess now until 2 o'clock to give the party some time to go over some matters and maybe help narrow the issues or come to some agreement. And with that, we'll be in recess. All right, let's come back to order. So for the record, we have finished the case in chief for MRT, the complainant. And we are at the stage where the respondent would put on its case, but in the meantime, the parties have come to me and they wish to put a settlement in principle on the record, which I think they're going to be following up in writing in a few days. So I will, Mr. Irby, it looks like you have the honors.
I do. Thank you, Madam Chair and members of the commission. The parties are willing to accept a substantial portion of the public staff's recommendation for MRT to pay 80% of the cost to establish capacity for approximately 28,000,
Was that 80?
80 lots, Your Honor. 80% of the cost, and which would produce approximately 28,800 gallons per day, which would serve approximately 80 lots within James Creek, the existing phase 1 and the expansion phase. With that said, 30% of that cost would then be recouped by MRT and tap fees as recommended by the public staff. The parties have agreed that Hisco will work with MRT's engineer to build a new wastewater treatment plant at present of unknown size, but which would be intended to partially or wholly replace existing capacity at the Harkers Point wastewater treatment facility and add MRT's new capacity. So by way of example, an 80,000 gallon per day plant would have 28,800 gallons allocated specifically for James Creek, and the rest of it would be used by Harkers Island Sewer Company. Also, by way of example, MRT would not be responsible for any cost associated with expanding the existing plant or constructing the new plant that would serve the existing customer base. MRT would pay 80% of its allocated 28.8 as opposed to, the full 80, if that makes sense. Within 30 days of today, Hisco will submit an application to the commission to approve a loan to cover its 20% share of the cost to cover the establishment of MRT's allocation of 28.8. Within 10 days of today, the attorneys for the public staff, MRT, and Hisco will work together to present a consent order to be considered by the commission. We'll submit it in Word document format so the commission can make whatever changes the commission feels appropriate. And in the interim, this hearing we've requested to be held in recess until October 6th. In the event that our proposed consent order is entered by the commission, that hearing would be unnecessary. Instead, we would request the commission require a series of updates through the next year to ensure that the settlement that we've come to in principle is moving forward. Did I miss anything?
I hesitate to muddy the waters at all, but I just wanted to make clear that what MRT is paying 80% towards is its 28,800 gallon capacity. I just wanted to be clear because the statement of they would not be contributing to other Harkers Island customers slightly ambiguous in my mind, because if it's a new facility, it will, of course, be serving Harkers Island customers, but the limiting factor for MRT is that it's paying 80% into escrow of
It's 28.
only its 28.
That's correct.
Whatever proportional amount that is of the new facility.
That's correct.
And this is the contributions go toward a new facility for Harkers Point.
That's the thinking, Your Honor. Instead of just paying to increase the capacity of the existing facility, given that the existing facility is at the end of its natural life, my understanding is it's better for everybody if we just build a larger new system, which MRT would obviously be required to pay for 80% of its 28.8, and Harkers Island Sewer Company would, take care of the rest of it. 20% of which would be approved it with a loan by the commission to facilitate it at a minimum expanding capacity to establish that 28.8 so that MRT could develop its 80 lots.
All right. Ms. Holt, do you have any thing to add, or is that in alignment with your understanding?
That's in alignment with our understanding, and we agree to it.
All right, anything else that needs to come before the commission with respect to this?
Not today, Your Honor. We will obviously be in touch with the commission over the coming 10 days regarding our proposed consent order, and we'd be willing to work with the commission to make whatever changes need to be made. Obviously, we've got a long 10 days ahead of us to try and put pen to paper to make sure this is properly documented.
So within 30 days from the day, we would get the application?
I think 30 days from today, we'd get the application. Hisco says it's got a pretty good idea of the amount that it's going to need to cover its 20% cost. It's going to request an amount over and above that just so that they don't fall short, given, inflationary factors.
So the commission will order that in the same 30-day time period, or +1 the day after, that a report or status report about the situation be made to the commission about where we are and if anything has changed with respect to settlement and the settlement staying on track.
Yes, Madam Chair, and candidly, I was going to request with opposing counsel and with the commission for regular status updates. We don't need to come in for hearings. If things are moving forward, I'm fine with one-page piece of paper jointly signed by both myself and Mr. Genest that things are moving forward. I just want regular status updates. I just don't want radio silence for the next year is what I'm getting at.
So we're going to continue the hearing until October the 6th at 1:00 p.m. in this hearing room. That hearing will go forward if the settlement is not on track. If the settlement is proceeding and progressing and parties are in agreement, we will convert at that point to 30-day status report. Every 30 days, indicate to the commission and to each other what's going on and where we stand with respect to getting the matter resolved. Does that sound good?
Yes, ma'am.
Any problems?
We agree. Thank you.
We agree.
I think that's it. All right, we will be adjourned or continued until October 6th.
Thank you, ma'am. Thank you, members of the commission.
Thank you.